Hello, everyone, and welcome to today's Law Path webinar. My name is Ryan Tan, and we're going to be covering the topic of the 6 steps to take to ensure a drama-free redundancy. So this is something that you're going through within the business right now of looking to move on staff or looking to do a redundancy, but you're not specific or sure on the rules to follow, then this is the webinar for you. Now, we're going to be joined by one of our lawyers in-house today, Sam Hown. He'll be jumping on in just a minute, but in the meantime, I'm just going to launch a general poll. Just want to gain a bit of feedback on your company's biggest focus in 2022, as well as what industry you're in. And we collect this data so that we're able to make the webinars customized to ensure that they're relevant for businesses like yours. So I've just launched the poll. If you could take a moment or two just to fill out those questions, and then we'll get started. Now, if there's any questions from today's webinar, feel free to comment in the chat or the Q&A box, and we will definitely attend to them at the end of the webinar as well. Fantastic. So thank you to everyone filling out that poll. So just while everyone's filling out the poll, I'll just cover off today's agenda. So we're going to be going through a bit about LawPath and what we do and how we can help. Then we'll be going through an introduction to Sam, and then we'll get straight into the topic today on redundancies. So the difference between termination and redundancy, avoiding an unfair dismissal claim, and tips to ensure a smooth redundancy. And then we'll go a bit on to how LawPath can help. We'll take some Q&As and go on to our legal health check as well. Thank you for everyone who has filled out the poll. So just a bit about LawPath, who we are and what we do. So we do provide smart, simple legal for small businesses through our documents library, our contract management system, our e-signatures, and our legal advice. And this provides a legal floor for your business in ensuring that you stay compliant with all the legal documentation and have up-to-date advice that suits the specific needs of your business. So as you can see here, we've assisted over 300,000 businesses. We've saved them over $100 million in legal fees. We've got 10,000 5-star reviews on Trustpilot and Google as well. So I'll just go on to Sam and introduce him. Sam is one of our in-house lawyers who assists out our customers through our legal marketplace and the legal advice plan. He has over 8 years experience in an array of legal areas, and he's a 5-star rated lawyer, our top employment lawyer, startup lawyer, and commercial lawyer. So he's going to be joining me now, and we'll go straight into the webinar content on redundancies. Thank you so much, Sam.
Thanks for that, Ryan, and hello, everyone. Thanks for joining us. So this is amongst one of a series of webinars that we've been doing on employment, the last one being the difference between contractors and employees. But employment is a big topic area for our clients and really for business owners generally, because it's a constant, it's a consistent, it's an area of law that affects pretty much every business, unless if you're a sole trader. Now, with redundancies, we've been fielding some inquiries about redundancies. The client's business is suffering from a downturn or a restructure. They're changing their focus to different business areas, and there might be some roles that are no longer necessary. And so those employees who are working in those roles might need to be moved on. And so the client would want to know how that can be done in a safe and legally compliant way. Now we're going to have a look at 6 different areas, starting off with what a brief discussion about what a dismissal is, and then we'll look into what a redundancy is, what a genuine redundancy means at law, alternatives to retrenching an employee and providing notice, and various payment liabilities that arise if you make somebody redundant. So what is dismissal? Now we're starting with this question because a genuine redundancy under the Fair Work Act is actually a defense. It's a defense against the claim for unfair dismissal. So if you dismiss an employee, it means that you have terminated the employee's employment at your initiative. Now, in some cases, an employee might be compelled to quit because of the employer's action. So the employer might not have said you're fired, but the employer might be acting in a way that basically forces the employee to resign. So those sort of scenarios constitute dismissal. If the dismissal is judged to be harsh or unjust or unreasonable, then it is considered unfair dismissal, and an employer can be ordered to pay compensation, which is at the moment, it's capped at $79,250, or up to 6 months worth of pay, whichever is lower. Now, an employee can be dismissed for various reasons. They might be persistently underperforming, even though you've set some clear expectations about performance standards and give them reasonable opportunity and assistance to improve. They might have committed serious misconduct, or your business might just not need their role anymore, and so you have to make them redundant. So we'll look at some of these issues. Okay, so first of all, if an employee commits serious misconduct, and the bar for what is serious misconduct is fairly high, there's been cases involving employees swearing at their managers and supervisors. There's been incidents of theft, usually of a fairly minor nature, and arguments about whether those actions constitute serious misconduct, and they really turn on the specifics of each case. But broadly speaking, if an employee commits serious misconduct, they may be dismissed, and in very extreme cases, they may be dismissed without notice. If the employee is unable to perform an inherent requirement of their job, and this usually arises after they've suffered some sort of injury, they may be dismissed. Now, there are bars and limitations to whether you can dismiss an employee who has been injured. But assuming that you have complied with various time limitations and obligations, if the employee is ultimately unable to return to their role, even after some reasonable adjustments, because they can't fulfill inherent requirements, then they may be dismissed. An employee might have fraudulently obtained employment. They might have faked their qualifications. They might have overstated their experience, etc. And in some cases, and in some serious cases, that can lead to dismissal. It can usually lead to some sort of disciplinary action, but in extreme cases, it can lead to dismissal. If an employee cannot meet clearly defined performance standards, and then they are put onto a plan to improve their performance, they're provided a reasonable opportunity and assistance in doing so, and it still cannot meet the performance standards, then they could also be dismissed. And last but not least, it may be a genuine redundancy. So your business may no longer require a particular role to be performed, and so the employee who is performing that role could then be made redundant. Okay, so redundancy happens if you don't need an employee's job to be done by someone, or by a employee, or your company becomes insolvent or bankrupt. Now, the overwhelming majority of circumstances is because redundancies arise because of some financial downturn in your business, or a refocus of business objectives, or some sort of a restructure or merger with another business, or a sale of a business. And so, those kind of situations might lead to a role or a set of roles not being required anymore. The various duties that make up those roles might be redistributed to other employees, and the employee working in that role might be laid off, or those duties might just not be required in any form or in any capacity. And so, because there is no role for the employee to fill, the employee may need to be redeployed, or if they cannot be redeployed, then they are made redundant. Their employment is terminated. So what is a genuine redundancy? So I mentioned earlier about unfair dismissal. If you dismiss an employee, then there is a risk that the employee may claim unfair dismissal. So they file an application with the Fair Work Commission saying that they've been unfairly dismissed. In order for them to succeed, the Commission has to be satisfied that the termination was harsh, or it was unjust, or it was unreasonable. Now, you can have some odd situations, like you could have a dismissal caused by a reasonable ground, but the way you went about dismissing that person might be harsh, or it might be unjust. You didn't give them an opportunity to respond, for instance. It may be harsh in that you haven't taken into account their personal circumstances, difficulties that arise if they were to lose their job, for instance. Even if the actual basis for the dismissal was reasonable. So you can have those kind of situations as well. It's a fairly complicated area. But a genuine redundancy is an absolute defense. So if a role is no longer required by your business, and you dismiss someone because that person is no longer required to fill, because the role is no longer required, and so therefore you don't need that employee anymore, and you can't redeploy that employee to another role, then that is a genuine redundancy, and it provides the employer with an absolute defense against the claim for unfair dismissal. Now, there are other claims that might be made, such as a dismissal being unlawful. So for instance, if you dismiss someone because of their age or their sex or their political views, then a genuine redundancy won't protect you against those kind of claims. But for a claim against unfair dismissal, a genuine redundancy is an absolute defense. Now we're going to have a look at these 3 points that you see on the slide, because in order for a redundancy to be genuine, the Fair Work Commission has to be satisfied that all of these 3 points apply. So an employer no longer requires the person's job to be performed. An employer has complied with any obligations for consultation that are set out in a modern award or an enterprise agreement. And it is not reasonable to redeploy the employee to another role. I'm going to have a look at a few case studies. We've discussed this one, so we'll skip over it. So the first requirement is that the role is no longer required. And so we'll look at a case called McNichol and Shape. So Shape Australia was a company that I think it was involved in construction and building, making building materials and such. And it suffered a COVID-related financial downturn. Several roles were made redundant, and including the claimant, Ms. McNichol's role as a project manager. There was also a hiring freeze put in place, and so that partially prevented Ms. McNichol from applying for other roles and being redeployed. And the case looked at all three requirements that we had that were outlined in the previous slide, but the main one was whether the role was actually no longer required. And Ms. McNichol claimed that her employer should have gone out of their way to preserve opportunities for it to be redeployed. So there were internal promotions. There was an employee who was internally promoted to the role of a project manager. There were 3 secondees from the New South Wales office to the Queensland office where she worked. And so she sort of argued that there shouldn't have been an internal promotion to the role of a project manager, because if a person hadn't been internally promoted, then she could have filled that role. She also said that the secondees from New South Wales should have been returned to New South Wales, and that she could have been redeployed or potentially redeployed to one of those roles. And then she also argued that her job was not redundant because parts of her duties had been redistributed to other employees. And so even though the role itself was no longer required, some of those duties were still being done by other employees. And so she argued that that meant that the redundancy wasn't genuine. The Fair Work Commission rejected all of these arguments. They said the Commission decided that the employer is not required to jump through hoops, those are the words used by the Commission, in order to find cost savings or to preserve jobs. And as for the secondees being returned to New South Wales, the employer is not obligated to remove employees, valuable employees from doing valuable work simply because they are seconded. And the Commission also noted that no other person was re-employed for the role of project manager after the redundancy. And so it wasn't like that the employer had gone and hired a replacement project manager or promoted another person into that role. The role just simply ceased to exist. And the Commission also ruled that it was reasonable for duties that formed a redundant role to be distributed amongst remaining employees. There was nothing wrong with that from the Commission's point of view. So that's an example of a case where the question of whether the role was no longer required was examined quite carefully. And so that was a genuine redundancy. Now, some modern awards and enterprise agreements impose consultation obligations. In fact, most of them do. And it's generally framed on the lines that if there is a major change to the workplace, and it's not just about roles, it's also about things like workplace health and safety, policies, changes that affect a significant number of employees. There is generally an obligation for the employees to be informed, for the employees' union representatives to also be engaged, and for there to be a discussion on the impact of those changes, and for the employer to seriously consider those impacts and try to mitigate against them before implementing those changes. There is also usually a separate obligation to liaise with individual employees whose hours and rosters will be changed. So if their hours are being reduced, or their rates of pay are being reduced, or their rosters being changed, then the individual employees who will be impacted by those changes need to be consulted, and their circumstances taken into account. Now, you can't force employees to sign new contracts or to accept a reduction in their pay or anything like that. But you do need to consult them, and if the employees do not agree and your business can no longer afford to keep certain roles, then you may be forced to make those roles redundant, make that hard call. Now, Sharma and GTS Australia, so this is again another case involving financial downturn caused or exacerbated by COVID. Mr. Sharma worked as a customs broker. There were two customs brokers working in the company, and the company decided that they don't need two. They can that aspect of the business can be performed by just one customs broker. So they had a look at the performance of the two customs brokers, and Mr. Sharma, unfortunately, was the lesser performing person by a significant margin. He only brought in 90% of revenue. The other person brought in 81%. So they made him redundant. Now, the problem with this is that they didn't consult Mr. Sharma. They just made a decision, and then they gave him a telephone call and said, look, your job's made redundant. Bye. So the Fair Work Commission looked at the circumstances and said, look, the reason for making him redundant, that was reasonable. It was reasonable to pick him over the other employee. It was reasonable for them to decide that two customs brokers were no longer required and could be reduced to one. So that's fine. But the way they went about the redundancy was wrong. It wasn't compliant with the Fair Work Act. So they should have notified him ahead of time about their intention or proposal to make the role redundant and given him an opportunity to respond, and have given him an opportunity to be redeployed if that was possible. But in this case, they failed on that obligation. And because they failed, it was not a genuine redundancy, even though the reason for the redundancy might have been a reasonable one. But technically at law, it was not a genuine redundancy. So then the Fair Work Commission had to consider whether it was unfair dismissal, whether the dismissal was harsh or unjust or unreasonable. And fortunately for the employer in this case, it was decided that the dismissal was ultimately, it was not harsh, nor was it unjust or unreasonable. And they said, look, ultimately, even if he was consulted, it probably would not have made any difference. It's pretty unlikely that they would have been able to keep that role, given the company's financial circumstances. So in that case, the employer was quite lucky and the unfair dismissal claim failed. But it highlights the fact that you do need to consult. If the award says that you have to consult the employer, you do have to consult them, and you have to genuinely take into consideration the impact of the redundancy on the employee and try to redeploy that employee if that's possible to do so. Now we'll look at redeployment a bit later. In fact, we'll look at it very soon. So redundancy is a form of dismissal. And if you do not adequately consider redeployment options, then it is not a genuine redundancy. Now you have to demonstrate that the dismissal is not unfair, that it is fair. So if the dismissal is not a genuine redundancy, then the onus is on the employer to demonstrate that it's not unfair dismissal. And redundancy is really treated as the last resort. So you have to consider the skills and the background and the knowledge that an employee has and see whether they can be fitted into some other role that is part of your business. Now, if you're say a company and you have subsidiary companies or holding companies and there are roles available in those other companies, then you have to also consider those roles as well. So it's not just within that one legal entity operating the business. If there are associated entities, you have to consider those other entities as well, whether what roles are available in there. So when it comes to redeployment, you've got to think about, are they qualified? Are they experienced enough? Do they have the necessary knowledge? What are their salary expectations, remuneration as well? And where is the job located? Like if they're originally working a role based in Sydney and a potential redeployment role has been, say, Darwin, then that might not be a viable option for a deployment. Again, if the role that they could be redeployed to is at a salary that's significantly lower than their current one, and the employee says, well, I won't really accept that, that's a bit too low, and you can't come to some sort of agreement or compromise about that, then again, it might not be, it's probably not a viable option. So you've got to take these things into consideration. And a case study on that is Philips and Boeing. Boeing, as you all know, is a very large aerospace company. And in this case, one of the Australian subsidiaries suffered a financial downturn due to COVID. Mr. Phillips was a materials handler, handling different materials that are used in the building of aircraft. And 12 of those roles, material handler roles, was reduced to 9. As part of notifying these prospectively redundant employees, Boeing gave them details. I think it was in the form of a document called Knowledge, Skills and Attributes, and it was a process and a matrix used to rank employees and decide who should be made redundant. And Mr. Phillips, unfortunately, had the third lowest score. So he was informed that he will be made redundant on the basis of this objective test. And the employer also ran a program to try and redeploy employees who were retrenched. And so there was a so-called mix and match program. And Mr. Phillips applied for a role, but was unsuccessful. Now, Mr. Phillips said that now in that role, in the role that Mr. Phillips applied for redeployment, another employee was successful, but then he later resigned. And then after that other employee resigned, the role was made redundant. And Mr. Phillips tried to argue in the Fair Work Commission that he should have been redeployed to that role. He also said that the company had outsourced some work to do with pin cleaning. I'm not sure entirely what that is, but in 2016, about 5 years ago, 5 years before he was made redundant. And he argued that the work should be insourced and he could be redeployed to work in that role. The Fair Work Commission decided that past decisions about outsourcing of work is not really relevant. Opportunities for redeployment should exist within the employer's enterprise or an associated entity of the employer at the time of dismissal. So, even though Boeing has outsourced some work in the past, that is not a relevant consideration when it comes to whether a person could be redeployed. Boeing should not be expected to insource that work in order to create opportunities for redeployment. It wasn't reasonable to assume that Mr. Phillips would be successful in getting the mix and match role that he had applied for. He had initially been unsuccessful. Another employee got hired for that role. That employee resigned. The role was then made redundant anyway. So the point was really moot. But the commission said, even if the role was ultimately not made redundant, there was no guarantee that he would have been found suitable for that role, especially given that other employees had also applied for that role and they might have been more suitable. And overall, Boeing had met the requirements for this dismissal to be a genuine redundancy. So one thing about redeployment is that an employee is not required to create roles for redeployment. The opportunities for redeployment, they should exist, and if they don't exist, then an employer is not required to go out of their way to try and create a role for the person. All right, so if it is a genuine redundancy, like all dismissals and terminations of employment, you've got to give notice. The amount of notice you have to give depends on the modern award or enterprise agreement that applies. If it doesn't apply, then the minimum amounts of notice are set out as set out in the slide. One thing that a lot of employer clients miss is that if an employee is over 45 years of age and it's completed at least 2 years of service, you've got to add another week. So refer to the modern award that applies to that particular role, and any enterprise agreements. If none apply, then have a look at the Fair Work Act and comply with the minimum requirement for period of notice. Now you can also pay out the employee instead of giving them notice. So if you were required to give them 4 weeks of notice, but you don't really want them to turn up to work, then you can pay them out the equivalent amount of remuneration. Okay, so if you make a employee redundant, there is redundancy pay that you have to give them. Now, not all employers have to pay redundancy pay. If you're a small business, that is a business with less than 15 employees, then you're not required to provide redundancy pay. If the employee is a casual, again, they're not eligible. If they're a permanent employee, then they have to have worked for at least 1 year in order to be eligible to receive redundancy pay. Now, redundancy pay is on top of the other usual termination entitlements, such as accrued annual leave, overdue wages, and so on. Okay, so some exclusions for redundancy pay. So, if the employee was a permanent employee and had been employed for less than 12 months, you don't have to pay. If they're on a fixed term contract, so if they're employed for a fixed period of time and they were made redundant because the contract had expired, then again, no redundancy pay applies. If they were hired for a season, like to pick fruit, for instance, and that season ends, and so their employment ends naturally as a result of that, then again, you don't have to pay redundancy pay for that. If they're fired because of serious misconduct, again, no redundancy pay. Trainees under a training agreement. Now, you might wonder what that is. It's their agreements to train people, usually alongside some formal vocational course, and they're agreements that are governed by state territory law, specifically for such trainees, as well as apprentices as well. And I mentioned employees of a small business are also not entitled to redundancy pay. So, but don't forget, that the dismissed employee is still entitled to other entitlements. So, outstanding remuneration, accrued annual leave, plus any leave loading if their award or enterprise agreement provides for one. Don't forget long service leave as well, which is a state and territory leave. It's governed by state territory law, not Commonwealth law. Some modern awards provide for sick leave to be paid out as well, so check your award about that. Some awards also provide for an employee to accrue time off instead of being paid overtime. And so if you dismiss those sorts of employees, then you may be required to pay them for the accrued time off that they haven't used up. If you're paying out the notice period, then you have to also pay that equivalent amount as well. Okay. So what is considered a small business? A little bit in a little bit more detail. So yes, fewer than 15 employees. You don't count casual employees unless at the time that they're dismissed, they have been employed on a regular and systematic basis, that they work regular hours on regular days. If the business is part of a larger group of entities, like if it's a part of a corporate group, then that whole group is taken to be one entity. The employee who's being terminated will also count towards the 15 employee threshold as well, along with all the other employees who are being terminated at the same time. Okay, so how much redundancy pay do you have to give? It depends on the period of service. So it ranges between none if they have not been working for at least a year, but if they have been working for at least a year, but less than 2 years, the redundancy pay is the equivalent of 4 weeks, and it can go all the way up to 12 weeks. And it's the amount of money they would have been paid if their employment had continued. So it's not strictly their base rate of pay. So if they worked regular overtime, they worked days where they would have normally been paid penalty rates. So if their roster included all those other loadings and allowances and penalty rates, then you have to take that into account as well. So it's got to be what they would have been paid if their employment had continued. And that's about it. Now, if you've got any questions, please pop them into the Q&A function, and then we'll go through them at the end of the webinar. And now I'll pass you back to Ryan.
Thank you for that, Sam. That was a fantastic presentation. So just wanted to go on to how LawPath can help. Now, just briefly, if you do have any questions on redundancy or things that Sam mentioned, please pop them into the chat or the Q&A, and we will get to them straight after this. So how LawPath can help, I think a lot of attendees here are very familiar with how we can help with the contract management side of the business. So we do have a number of employment documentation, employee handbooks. We have about 101 right now, different employee and HR related documents on there, including like deed of release, the termination, and plenty of other related documents. So they're definitely available amongst 370 other documents. We do have personalized workflows as well. So specifically on this topic, there is a workflow on dismissing an employee and the right steps to go about that for your particular circumstances. And then lastly, booking in legal consultations. So particularly around this issue, it's a very specific area of law, as Sam mentioned, and you want to ensure that you get it correct. So it's a fantastic opportunity to book in a call with a lawyer using our documentation to run it by them and ensure it's compliant, so you can avoid, say, a breach of the Fair Work Act. So here are a few different plans that we have at the moment. We've got our Essentials plan, which is the access to the documents library. We've got our legal advice plan, which gives you on-demand legal advice with our lawyers, such as Sam and our other in-house lawyers. You can get contracts reviewed up to 4 pages as well. So it is a fantastic opportunity to ensure the documentation on the website is compliant and correct. And then lastly, we have our legal and accounting advice plan. So if you're looking for some chartered accounting advice right now at a high level on the business, such as group structuring and asset protection, then this is a fantastic plan to consider. So from today's webinar, we've got an exclusive offer for our legal advice plan where we're offering it 20% off. Now it's $100 a month with an annual commitment. It does include monthly billing. So if you go to our website, our new customers will be paying $120 a month, and that's billed annually. But for everyone on today's webinar, not only do you get 20% off, but you can secure it with monthly billing. So if you'd like to take up our offer, comment yes into the chat or the Q&A box, and one of our team will reach out after the webinar. Now, again, this is a fantastic opportunity. If you'd like to firstly consider a redundancy or how you can consider employee exits in general, getting your action plan together, the documentation, but maybe you don't have a specific reactive circumstance in the business right now. And in that regard, you can think more proactively around how you're structuring your employment, making sure your contracts are up to date, and ensuring that, again, you're fully compliant, because there are regular changes, specifically within employment contracts around the award, payment rates, etc. So it is good to be thinking about that. Now, one other thing we do offer on this legal advice plan is an accelerator program. This program gives you 6 different topics, one of them in which is employment and HR. So our lawyers can do a holistic legal health check across your business and view employment contracts, policies to ensure that they're compliant, as well as a range of other topics such as intellectual property, privacy and insurance policies, and capital raising as well. Now, we do have a referral program as well. So we can pay up to $200 for every successful referral to the legal advice plan. Now, if you'd like some information on this, comment referral in the chat and one of our team will reach out after this webinar. It's fantastic if you're working in professional services as an accountant, maybe you're a lawyer as well, and you have people that you can refer on to us and add value to them, but you can also earn some money as well. So if you are keen on that, comment referral in the chat and we will be in touch. So I'm going to take some Q&As from Sam now. So again, feel free to place your questions here.
Thanks, Ryan. Just go through some questions that have been asked. Okay, so Shelley, you asked if the dismissal is genuine. I'm assuming you mean a genuine redundancy. But the employee relies on the income from this role for his family, can the business still dismiss? Basic answer is yes. If it's a genuine redundancy, then you can dismiss that person. Even if, in other circumstances, it might be, the outcome might be a bit harsh for the person. But yeah, so if it's a genuine redundancy, then the harsh, unjust, unreasonable test does not apply. So that's the key, whether it's a genuine redundancy or not. Daryl, you asked, is dismissal or redundancy the same during the employee's 6-month probationary period? Okay, so an employee cannot make an unfair dismissal claim if they have not been working for you for at least 6 months. If you're a small business with less than 15 employees, then that period is increased to 12 months. So if you dismiss someone during that time, then they cannot make an unfair dismissal claim. Now, they can make other claims, like if they queried their pay and you fired them because they had the temerity to do so, then that'll be a breach of general protection, and they could make a claim on that ground. But on the basis that they can't make an unfair dismissal claim on the basis that the dismissal is harsh, unfair, or unjust. Now, if it is a genuine redundancy, so if you hired someone and your business underwent a restructure shortly after, and that role was no longer required, then you can make that person redundant. And the requirements do not change whether they've been employed with you for less than 6 months or more than 6 months or for any period of time. What will change is how much you have to pay the redundancy pay and the other employment entitlements. So when it comes to assessing whether a redundancy was genuine, the length of their service is not really a relevant consideration. Now, that was a bit of a long-winded answer, but I hope that answers your question. Okay, so Lee, you asked this question about whether a role continues, but not as a full-time role. So if the hours are severely reduced and the employee who's working that role doesn't want to agree to the reduction, then could it be a genuine redundancy? The answer to that is yes. So if the role, the capacity of work that's taken up in that role, if that changes, and so you no longer require that role to be full-time, but there's a serious reduction in the number of hours, and the employee doesn't agree, then you may have no choice but to make that person redundant. I'll just note that it's not it's not the person that's made redundant, it's the role that's made redundant. So the full-time role is made redundant, and instead it needs to be a part-time role. And if the employee doesn't want to change to a part-time employee, then that person would have to be either redeployed to a different role that they can work in, or be made redundant. Okay, so Angela, you asked if you're making roles redundant and the employee is in their probationary period, can you terminate due to redundancy, or can you terminate as part of their probation period? So it's not performance related, or you don't cite any reasons about redundancy. Then you can do either, really. So it's sort of up to you how you want to frame it. And a factor in that decision might be whether you think one might be better received than the other. But generally speaking, if an employee has only been working for a very short period of time, like less than 6 months, and you want to dismiss them, you're not obliged to provide them with a reason. You just, unfortunately, your role is not required, or we don't find you suitable, or there's been a change in business operations, etc. You can just dismiss. Just as long as you're not dismissing them because they've exercised the workplace right or some protected attribute, you should be fine. Another anonymous question: if the dismissal redundancy is genuine, but the employee relies on his income, can the business still dismiss and make them redundant? The basic answer is yes, as long as it's a genuine redundancy. What is the situation if the owner of the business decides to sell the business? So it's not really relevant, actually. So if the owner of the business decides to sell, then the buyer has to make a decision about whether they're going to retain a particular employee working in a particular role, or whether they're going to hire somebody else or not keep the role. So a lot of that will be driven by the intentions of the purchaser. But genuine redundancy is not really a relevant consideration when it comes to sale of a business. When it comes to sale of a business, it's what roles will continue in and under the hands of the new owner. That's what you need to think about, and a lot of that will be driven by the intentions of the new owner. If a redundancy is genuine, can an employee who is on workers' compensation be made redundant? This is a bit of a tricky question. So the general rule of thumb is that you cannot make a worker who is on workers' comp, you cannot dismiss a worker who is injured because of their injury, even if that reason is only part of the reason. So if the fact that a worker is unfit for work is in any shape or form part of the decision to make that to let that person go, then you cannot dismiss, and there are time frames in which you cannot do that. So under state, territory, workplace health and safety in workers' comp legislation, it might be 6 months. Under the Fair Work Act, if an employee is absent for an aggregated period of 3 months as a result of an injury or an illness, then you cannot dismiss them because of that absence. So there are other things at play, but ask for some advice about your specific situation, because it's a little bit complicated. Sarah, your question: the redundancy pay is included sick leave and annual leave? I think, sorry, you use some abbreviations here. I think you mean annual leave, or is this on top? So redundancy pay is on top of all those entitlements. So it's on top of accrued annual leave, sick leave if the award requires sick leave to be paid out, and overdue wages, etc., etc. If a business goes insolvent, at what stage will redundancy begin? ask an insolvency practitioner would be my answer to that one. So you can still have a genuine redundancy as part of an insolvency process, but what roles are made redundant, etc., and when they're made redundant would really depend on how you restructure the business and refocus the business as part of the recovery out of insolvency. And okay, so sorry, the last question was a repeat of the previous one. I think that's about it. Okay, I'll pass back to Ryan.
Perfect, Sam. Thank you for that. And thank you everyone for your questions. So if there is any last comments or questions, feel free to comment them now in the chat while we still have Sam on. But just to reiterate and highlight the webinar offer again, the 20% off our legal advice plan and the referrals as well. So if you are interested, please comment yes, and we will be in touch. I'm just going to put a feedback poll up now just from the webinar today. If you could just let us know your thoughts and feedback and what you'd like to hear in the future as we do look at this data and customize it each week. So I've just launched the poll, but thank you everyone for your time and your attendance at today's webinar.